Justice denied anywhere diminishes justice everywhere. Martin Luther King Jr. Hello friends, welcome to my channel Indus Educare. And in this video, we are going to discuss about the principles of natural justice. So let's begin with the introduction of the topic. Principle of natural justice is derived from the word jus natural of the Roman law, and it is closely related to the common law and moral principles, but it is not codified. It is a law of nature which is not derived from any statute or constitution. The principle of natural justice is adhered to by all the citizens of civilized state with supreme importance. Natural justice simply means to make a sensible and a reasonable decision-making procedure on a particular issue. It is not restricted within the concept of fairness. It has different colors and shades which vary from the context. There are three basic rules of natural justice: hearing rule, bias rule, and reasoned decision. We will discuss these rules later on. Let's have a look at origin of natural justice. The principle of natural justice is a very old concept and is originated at an early age. The people of the Greek and Roman were also familiar with this concept. In India, this concept was introduced at an early time. Kautilya had acknowledged the concept of natural justice. Natural justice is a sense of what is wrong and what is right. The principles of natural justice originated from the common law in England and are based on two Latin maxims. And those are Nemo judex in causa sua and Audi alteram partem. Now let's see the purpose of the principle. To provide equal opportunity of being heard, to fulfill the gaps and loopholes of the law, concept of fairness, to protect the fundamental rights, basic features of the Constitution, and no miscarriage of justice. The principles of natural justice should be free from bias and parties should be given fair opportunity to be heard, and all the reasons and decisions taken by the court should be informed by the court to the respective parties. Let's see the principle of natural justice one by one. The first is Nemo judex in causa sua. From this picture, you can understand the meaning of this principle. No one should be a judge in his own case because it leads to rule of biasness. Bias means an act which leads to unfair activity, whether in a conscious or unconscious stage, in relation to the party or a particular case. Therefore, the necessity of this rule is to make the judge impartial and give one judgment on the bias of evidence recorded as per the case. Following are the types of bias: personal bias, pecuniary bias, subject matter bias, departmental bias, policy notion bias, and bias on the account of obstinacy. Let's see them one by one. Personal bias. Personal bias arises from a relation between the party and deciding authority. Such a relationship disqualifies a person from acting as a judge. In order to challenge the administrative action successfully on the ground of personal bias, it is necessary to give a reasonable reason for bias. For example, the case of A.K. Kripak versus Union of India. The Supreme Court quashed the selections made by the selection board on the ground that one of the candidates appeared before selection committee was also a member of the selection board. The second type is pecuniary bias. If any of the judicial body has any kind of financial benefit, howsoever small it may be, will lead to administrative authority to biases. The third type is subject matter bias. When directly or indirectly the deciding authority is involved in the subject matter of a particular case. For example, Muralidhar versus Kadam Singh. The court refused to quash the decision of election tribunal on the ground that the chairman's wife was a member of Congress party whom the petitioner defeated. The fourth type is departmental bias. The problem or issue of departmental bias is very common in every administrative process, and it is not checked effectively, and on every small interval period it will lead to a negative concept of fairness will get vanished in the proceedings. The fifth type is policy notion bias. Issues arising out of a preconceived policy notion is a very dedicated issue. The audience sitting over there does not expect judges to sit with a blank sheet of paper and give a fair trial and decision over the matter. And the last is bias on the account of the obstinacy. This new category emerged from a case where a judge of Calcutta High Court upheld his own judgment in appeal. A direct violation of the rules of bias is done because no judge can sit in appeal against his own case. The second principle is audio alteram partem. It means that no person can be condemned or punished by the court without having a fair opportunity of being heard. The literal meaning of this rule is that both parties should be given a fair chance to present themselves with their relevant points and a fair trial should be conducted. This is an important rule of natural justice and its appeal form is not to penalize anyone without any valid and reasonable ground. Prior notice should be given to a person so he can prepare to know what charges are framed against him. It is also known as a rule of fair hearing. Let's see the components of Audi Ultram Partem. The first is issuance of notice. Valid and proper notice should be given to the required parties of the matter to further proceed with the procedure of a fair trial method. The second is a right to present the case and evidence. After receiving the notice, he must be given a reasonable time period to prepare and present his case in a real and effective manner. The refusal should not be done on the unreasonable ground or due to arbitrary. The third is right to cross-examination. Right of fair hearing includes the right to cross-examination the statement made by the parties. If tribunals deny the right to cross-examination, then it will violate the principle of natural justice. Cross-examination is defined under the Section 137 of the Indian Evidence Act 1872. In the case of Ludhiana food product, the court held that if the party itself refused to cross-examine the witness, then it will not fall under miscarriage of natural justice. The fourth is a right of legal representative. In the process of inquiry, every party has the right to have a legal representative. The third principle is a reasoned decision. The aggrieved party has the chance to demonstrate before the appellate and revisional court that what was the reason which makes the authority to reject it. It is a satisfactory part of the party against whom the decision is made. The responsibility to record reasons works as obstacles against arbitrary action by the judicial power vested in the executive authority. Still, there are exceptions to the rule of natural justice. Exclusion by the statutory provisions, exclusion by the constitutional provisions, exclusion in case of legislative act, exclusion in public interest, exclusion in case of the need of prompt action or in emergency or necessity, exclusion on the ground of the impracticability, exclusion in case of confidentiality, exclusion in cases of academic adjudication, exclusion when no right of the person is infringed, exclusion in the case of interim prevention action, and exclusion in case of fraud. Finally, the conclusion. The principles of natural justice have been adopted and followed by the judiciary to protect public rights against the arbitrary decisions by the administrative authority. One can easily see that the rule of natural justice include the concept of fairness. They stay alive and support to safeguard the fair dealing. The principle of natural justice is not confined to restricted walls of the applicability of the principle, but depends upon the characteristics of jurisdiction granted to the administrative authority and upon the nature of rights affected of the individual. Thank you, friends, and good luck.